All right. Good morning, everybody. Welcome to 2025. God, thank you so much for powering up and doing some of these sessions with us this year. We always look forward to knowledge being imparted to us, to growing, to being better, being more professional. Welcome, everybody, to the sessions. Tinas, I just want to ask, is that Zoom big enough? Tinas, are you happy with the size font? Perfect. Garth, thank you so much. I'm going to hand it over to you this morning to give us the power and the knowledge. And again, thank you so much for doing these sessions. I see we do have Leapfrog Property Group, our head office with us. Leanne, did you want to say anything?
Yes, sorry for interrupting. Good morning, everyone. Garth, Brenda sent me a new presentation, so it is available for you to select. It's 7 pages compared to this one that you've got on here. I was just not sure if you've got the correct presentation up.
I've only got the 3 pages. How do we get to the 7
Can
pages?
let me just get that one quickly and then you can let me know if that's correct. Sorry,
Thank you.
everybody.
No problem, Leanne.
That's the correct one. Thank you. Sorry,
Okay,
that's our fault. I just wanted to add a little bit more to it. So
all right.
I wanted to add it to it. Okay.
Okay, cool. Thanks, everyone.
Cool.
Bye.
Thanks so much. Cheers. Bye-bye.
Thanks, Leanne.
Okay. Shall I start?
Yeah, Garth, we are able to send these notes to the delegates afterwards.
Definitely. We'll definitely send them through.
Super. Thank you.
Okay, great. Hi, everyone. So I've been asked to speak about FICA, and I know that you guys are probably sick and tired of FICA, but I think why it's been asked to be spoken about again, is that there has been some huge fines that have been levied. With the attorneys' practices, there's 3 firms that we know of. One was 7 million rand fine, one was 3 million rand fine, and one I think was about 1.5 million. I've seen quite a few state agencies where between 300 and 2 million rand has been levied for fines. So it's coming, not a talk that we spoke about, well, FICA is going to come in and maybe they're going to fine us one day. They have aggressively decided now to come after everybody. And if everything's not in place, they basically just start adding on the fine. So you can do one thing right, and they say, okay, tick, we don't have to fine you for that, but there's another part, and we're going to fine you for the next one, and the next one, the next one, until basically they can basically bankrupt an estate agency. And I bet, being obviously property petitioners, the principal is not going to be too happy with you and try to levy that on you as well if you've messed up as well. So it's something that is extremely dangerous for the state agency, but also for you as a property petitioner, because there will be possibly some type of personal liability depending on your employment contracts, and we just obviously want to avoid all of that. I'm going to quickly go into the history of it. It's something that it just makes you understand it a bit better. So again, it started off with a guy called Al Capone. Al Capone was a notorious gangster, and every time everybody tried to get him put in jail, all he did was those witnesses decided that they wanted to go swimming with lead boots in a river or a dam, and they never made it to the witness house. But some clever cop along the way said, well, he's got all these houses and cars, but he's not paying tax. So there's obviously tax fraud, and they got him for tax fraud. Now you had all these bad guys realizing now, especially in America, that they had all this ill-begotten gains, but they haven't paid tax. So how do we fix it up, did they say? And they started to do something called money laundering, which is basically money layering. So what they would do is they would go pay money into, for example, a Leapfrog account to buy a property, and then say to Leapfrog, listen now, actually I'm going to cancel, keep your commission, but just pay me back the money, the rest of the money, and they get paid out. Then they would come to Dykes and Plessis, buy a property, put the money in, and say, oh, you really wanted to buy that property, but somebody died in my family, and please can you pay the money back? You can take your wasted costs. And they lose a little bit of money along the way, but by the layering process, they have basically cleaned it from drug money, for example, to Leapfrog's money, to Dykes and Nell's money, Dykes and Plessis money, and then they keep on layering it until it's basically clean money. And South Africa became the prime place to come do money laundering. Why? We had no laws around it. And it was very easy to come over, bring the cash over and start money laundering it, then go back to America and say, no, this isn't dirty money. I went and bought property over in South Africa, or I invested in South Africa. It's all clean money. Try to prove me wrong. And that was a problem. So the South African government eventually started to have to put things in place. It sounds great that all the money was coming in, but we had two problems. The number one problem was obviously a lot of bad guys were coming along the way, bringing crime with them, but obviously America wasn't too happy with it as well. And I think they started to apply a bit of pressure on South Africa to start increasing the money laundering laws. And out came FIC. And we all got a big fright and we worried about FIC. And FIC basically was a reporting system. So it basically said you could have any relationship with anybody that you wanted, but if there was, under certain circumstances, you had to report. And that was a monetary threshold, if someone paid in more than a certain amount of money cash, or if there were suspicious transactions. And you know what we all did? We kind of reported it, but 99% of the stuff went unreported. And FIC realized, no, this is not working. So out came the FIC Amendment Act. And this is the one that we're dealing with now, which has quite a lot more responsibility on us. And we have to make sure that we follow the correct process. Otherwise, we can go to jail for a long period of time or obtain these massive fines that go into millions of rands. It will shut down and bankrupt all of us if we had to get the maximum fine. So we have to adhere to the reporting system and the new Amendment Act. I'm going to go through the Amendment Act as well as the new matrix that we all have to follow, which I will go quickly through. So we only have a small amount of time, so I'm going to quickly go through it. So for every state agency, you have to have something what is called a RMCP. That's a Risk Management and Compliance Program. So for any of the principals out there, if you do not have an RMCP, please contact me immediately. We've got ones drafted up. Obviously, you can't use ours verbatim, but it's a good start. You've got to go through it, and then you've got to go and send it out to all your employees, which includes all the property practitioners, and let them know this is our RMCP. They must go through it and send back an email or sign it to say they have read it and understand the contents of the RMCP. The RMCP basically says, explains what is a suspicious transaction, what is the process that we go through with FICA, and we do a point by point on how to report and what is the process involved. So it's very important for the principals to have one, send it through to all the staff, and get a confirmation back that it's been read and understood and signed off. And with going with that is training. So if you have an RMCP and you wish for us to come through, we'll go through your RMCP and we'll assist with your training, something that you can do yourself. You will have a FICA compliance officer inside your offices, and they can also do the training on that. But we are more than welcome to call us anytime to help with the RMCP or the training. But this talk is mostly for the property petitioners on and how to do the reporting. So the initial act, remember, you had suspicious transactions and monetary limits, and those had to be reported, and you could carry on your day, basically, and you had to collect your FICA documents. But you know what happened? We kind of collected our FICA documents, and if somebody didn't give us one or two documents, we basically carried on with our lives, and it was very weak, basically. But the Amendment Act has put a stop to that. So if we look at the top of there, it says Section 21 is amended such that when an accountable institution engages with a prospective client, and remember the word prospective because we're going to go through it now, to undertake a transaction or establish a business relationship, it must establish and verify the identity of the client or such other person acting on behalf of such client. So that's like an agent, not like an estate agent, but an agent that acts on behalf of somebody else that's got a power of attorney or something like that. So it's very, very important is that when we have a look at the word prospective client, it's not just a client, but it's a prospective client. So some attorneys were arguing that when somebody comes and views an open hour, that is a prospective client and you've got to FICA them. And every property petitioner said, are you crazy? We had to go and FICA everybody that came into the show houses. It would obviously be a huge accounting problem. And it would also cause a lot of problems that no one would come to us. They'll just go to the next property where they don't have to be FICA. No one will come in and do FICA. So it's one of those things that haven't been clarified by FIC, but it's basically, you've always got to say, look at the purpose of the act. Would they want to do open house? And it's probably not going to be a requirement, and no one's doing it at the moment. So I don't think they could ever hold you liable for it. But a prospective client could be somebody that they have been driving with you for a couple of times. They're looking for property after property, and they're saying, find me a house, find me a house. And you've driven around and showed them various houses, even though they have not put pen to paper to sign an agreement to sell. You would have to eventually say, okay, you are a prospective client. We're going to have to go through the FIC process with yourself. It's not the end of the world in that you can use our notes to show them that by law, you have to do it. But number two, at that stage, you can also see if they have the finances. So while we do the FICA, let's also do like a pre-approval and get all their finances. So you're not wasting your time driving around. And I'm sure you've all gone through it, because I've heard the stories where you drive around somebody through to 10 properties for 5 million rand, and then you find out they can afford a house for 500,000 rand and you've wasted your time. So it's a nice way to make sure that you can look at their finances and make sure that they're not time wasters. Okay. If you look at 21 big A, which is the next point of there, provides that in addition to the information required to be obtained in terms of section 21 and the RMCP, which you have to follow, the institution must basically, and I'm going to jump a bit here, have knowledge of the following. And this must be done by way of a separate document or in your offer to purchase where you obtain this information. So you can't say that I've collected my FICA documents when you've got the ID and proof of residence and say I'm done. It's not done. You have to ask these questions and obtain this information. So number one, the nature of the business relationship concerned. So the nature of the business relationship concerned would obviously be you as a property petitioner trying to find a property for the potential purchaser to buy a property. Then the intended purpose of the business relationship is to buy a movable property to live in or for investment purposes. And then C, and this is the very, very important one, the source of the funds which that prospective client expects to use in concluding the transaction in the course of the business relationship. It's not sufficient to say that it's money. You can't just say it's money. It has to be money from my earnings, money from my granny who gave it to me, money from the lottery. They have to give you the source of the funds, and basically they're going to have to give some kind of proof behind it. You've got to do diligency, but your FICA officer will obviously obtain it. So when you're signing off to purchase, make sure that they when they say money, you say money from where, and they will go from my gran. You say that's fantastic. We just need some kind of proof that it came from your gran, and you write money from gran inheritance. Okay. Next one, Section 21B sets out additional due diligence measures to be formed by institutions when dealing with legal persons, trusts, and partnerships. Just remember, partnership is two individuals in theory, and they come to you and say, I'm in a partnership. You think, well, you both are individuals, so I don't need any more excessive due diligence. It's not true. If it's a partnership, it's seen the same as a company. So it's very important to remember that, including determining, and this is what you're going to have to find out with legal persons, trusts, and partnerships. You have to look at the nature of the client's business and the ownership and control structures of the client. So in the nature, fish and chip shop, very easy. And then you have to look at the ownership and control structures. Who are the directors, who are the managers, and they have to write it down in theory. Okay. Section 21C is very, very important, and most property petitioners are missing out on this one, and this is where some of the fines are coming from. institutions must conduct an ongoing due diligence investigations. It's not sufficient for you to say that I've done my FICA right at the beginning, and now if I can just stop and I don't have to carry on with it. There's an ongoing due diligence. And the one that really pops up is when you sign an offer to purchase for a bond of 100%. The purchaser gets a bond of 80%, and now there's 20% coming from the funds. Because there's an ongoing due diligence, you can't just do an addendum and say 20% to come from a deposit. You have to go back to 21 big A, and you have to put the source of funds. Where is that money coming from, and why? And you have to say, okay, it's cash. Where is it coming from? Okay, from your granny inheritance, and you have to collect that information. So there's an ongoing due diligence. Don't think you've done it in the beginning, that you're done, and that you don't have to. You have to do it right until date of registration. If anything changes, ongoing due diligence. Don't forget it. For all property petitions, what I recommend, you've got a FICA officer, work with them, but open a file. Do your initial FICA documents that you need to do, and keep an eye on it. If there's a change in circumstances, let's say a change of purchaser, sometimes they want it in their trust now, not in their personal name, or there's a change of how it's going to be paid, FICA them again, and have your ongoing due diligence and have a file for that person, and pack it away and make sure it's safe, because you just don't want to have a situation, which we actually had at our offices, where the police actually arrived and they asked for one of the files. And they said that if the FICA documents weren't on file and the report was done, because there was money laundering done on the file, that they'll be taking in one of the directors for questioning. And unfortunately, I was the only director there, so I saw my life flash before my eyes sitting in a jail cell. But I was very lucky in that report, the FICA was done, and we had reported them to FIC. So the report was on top of the file saying we had reported them. So remember, suspicious transactions or anything which we'll go through now, report. The nice thing about reporting is that your clients won't know you reported them. You're actually not by law allowed to tell them that you reported them. And the investigation will be done behind the scenes. And if there's nothing wrong, nothing will ever happen to that person. They won't know that you reported them, and you'll still have a good relationship. If it's a bad person, then obviously they'll come and pick them up. So don't not report them because you're worrying about ruining the relationship. They won't know. And like I said, by law, you're actually not allowed to tell them. It's called tipping off, and you can go to jail for it. So don't tell them that you're reporting them. Okay. Next one, 21D. If an institution doubts the adequacy of the information previously obtained, they must repeat the steps 21, 21A, and 21B. That's the stuff that we just spoke about above. If you don't believe it's right, or that something's changed, you've got to redo it. And just remember that the old act, I'm going to say the old act, but the initial act, you could try to obtain information. If they didn't give it to you, you could carry on. Then the amendment act says if you don't get all your information, you're not even allowed to start a relationship with the client. So if the client says, I'm not going to give you your FICA documents, you say, whoa, then we have no relationship. I cannot start a relationship with you unless you provide it. And then you must report them anyway because they don't want to give it to you. But you have to obtain everything. You can't, when the FIC officers arrive and say, I was expecting the lawyers to do it, or I got some of it and I didn't report them because, I didn't want to cause a fuss or anything like that. You're not even allowed to start a relationship with the Amendment Act. Very important to remember. They're taking this very, very seriously. Like I said, fines and jail time are a real possibility now for all of you. Okay. 21E, it says the institution is unable to establish or verify a client's identity or conduct, and ongoing due diligence the institution may not establish or continue the relationship. So like I said, if you cannot obtain all the documents, you can't start the relationship. If you have to re-FICA them and they don't give it to you, you cannot carry on the relationship. You have to stop and report, and then you have to pull back. It sounds terrible because you imagine you're doing this ongoing due diligence. The guy gets a bond and it's for a lesser amount. Now you have to re-FICA them. And the guy says, no, you're irritating me. I'm not going to re-FICA. Then you've got to stop there. If you've got a valid deal, they can go ahead. You have to stop and not go ahead. So it's very important that you speak to your clients beforehand. Say that you're governed by the FICA Amendment Act and that these are the duties on you by law, and that there will be an ongoing due diligence. If anything changes, that you have to refigure them, and let them know right in the beginning. Don't let them, when they get the bond for a lesser amount, say, now I have to refigure you, because the guys get upset. Let them know that right in the beginning, this is the act. Maybe hand them something and say, this is by law what I've got to do. It's not anything against you. You know, when you go to a gambling place, a casino, it says, there's a big sign up in a lot of the places, it's not personal, it's the law. And I love that. Say to them, it's not personal. It's not because of the color of your skin or your nationality or how you speak that I'm featuring you. If it's law that I have to do it, and if I don't do it, I can go to jail and I can get a fine. And in theory, they're going to do a huge investigation into you if you don't, because in theory, you have to report them. So it's very important that they know that it's not, you're not picking on them as per se. Okay. The next part of the 21E, F and G, and 22A is all basically in terms of what you have to do. It's called a risk assessment. So every client that you get now, and your FICA officer will do this for you, has to look at the risk assessment of the parties. I'm struggling actually to get to the top of this one to actually see the top of it. Okay, let me just scroll down. Okay, so I'm just scrolling. I'm having a little bit of troubles here. Okay, so there are 3 steps. I've given you an example of an attorney's risk assessment that they have to do. If you guys don't have a risk assessment platform, you can get, there's online ones that you can buy a package with them and they help you, or you have to write out your own risk assessment, which your FICA officer will assist you with. But it's very, very important that you have one, and for every client you do a risk assessment to see if they're a low risk, medium risk, or high risk. And I'm not going to go through the whole thing. You can go through it in your own time, but it's very important that your risk assessment is based on an estate agency and that you do it for every individual. So the first one is client risk assessment. You look at the client and you put it into your matrix here, and your matrix will tell you if it's a low risk, medium risk, or high risk client. So South Africa is a citizen between 1 and 2. We know that's pretty safe. But you can have a look of there. An SA registered company limited is already, we've got it as on this platform as a 3 to 4. It's a higher risk. But you'll see some of them are higher risk than others. Okay. So deceased estates, higher risk than obviously an individual, and your risk assessment, everybody's will be slightly different. There's no set one. It's what you put as a medium, low, and higher risk. And this basically matrix is different for everybody, but you're able to find out, basically work out on a objective point of view if someone's low, medium, or high. It mustn't be a subjective point of view, it must be objective. And that's how you use this matrix. Okay, so you can go through in your own time. Like I said, the first we look at is your client risk assessment, and you do a screening. Then you look at the transaction risk assessment. So you looked at your client, is your client high, medium, or low? And then you've got to look at the actual transaction. Is a transaction high, medium, or low? This one's obviously done for attorney's firm, so yours will be slightly different, but you'll say, is it higher risk or lower risk if you do a sale or a rental, and you'll make your own matrix. And then you look at your risk indicators and red flags, and you'll have your own matrix. If an agency doesn't have a risk assessment matrix and you don't have a system to do it, please let us know. We'll help you draft up one based on the risks that you got, and then basically it'll kick out what is, if the person's a high, medium, or low risk. If it's high risk, you must automatically report. And there are certain transactions we put in there that are suspicious transactions, and you report it anyway. If you're uncertain to report or not, you must report. We had a matter in our offices where the lady was bringing money in from overseas. She claimed that she paid it to a company that helps her get money into the country, and they paid us. It came out that it was actually a friend of hers, company, and they paid us. That is obviously extremely high risk a transaction. I'm not saying that there was anything untoward of it, but she had lied to us already about the first part of it, and we reported her. So it's extremely important that if you're uncertain, report. Like I said, they'll do the investigation behind the scenes, and it'll pop out hopefully with nothing, and your transaction will go in the small chance that it is illegal. They'll grab the person, obviously. But they still won't even know it was you that reported. And remember, there's a dual reporting. Just because you got your attorneys and they are reporting doesn't excuse you as the property petitioner not to report. FICA has come out and said that if the attorneys report and the property petitioner doesn't report, the property petitioner is getting the fines and going to jail. So you both have to report, the attorney and the property petitioner. That's very, very important that you do it. And especially because you've got an attorney, when they report, the first thing they're going to do is say, why didn't the property petitioner report? So it's very important that you're in contact with your attorney the whole time. And if they're going to report a transaction, they feel that is suspicious, that they contact you and say to you, we are going to report this transaction. We suggest you as well, you might not see it as suspicious, but we see it as suspicious, and rather do the report with them so that you don't have those problems. Okay, so please contact me if you need your RMCP, if you need your matrix, your risk matrix, and we will help you out with whatever you need. Also, the training has to be an ongoing training. So if you need training on any of those things I've just mentioned, we'll come to your offices. We'll bring some nice snacks. We know attorneys are boring, and we'll quickly get through some training for you guys, and you get your certificates with it. So for your non-verifiable points, if you sit for an hour and listen to me drone on about an RMCP. Okay, so guys, I'm going to leave it at that. With FICA, I could talk for probably 5 hours and not get through everything. But just please make sure you've got everything in place, you're asking the questions, and that you have a FICA reporting officer that is doing all of this, because the consequences are dire. And I can pretty much get you out of just about everything if we go to court and stuff over contracts and things like that. But things with FICA and stuff like that, you've got a very, very hard fight with you if they come after you. And I just don't want you guys to ever be in that position that somebody's knocking on the door with the police and saying you haven't done your duty, or putting a 2-3 million rand fine on you. Okay, please contact me if you need anything ever. In general's times, my cell phone is available. If I don't get hold of me, just drop me a WhatsApp and say, Garth, I'm looking for you, I've got a question, and I'll do my best to get back to you as soon as possible. And thank you for your time, everyone.
Thank you so much, Garth. I think this was very important. As I saw beginning of December, there were a lot of FICA fines implemented on various agencies, especially here in the Western Cape, and they were pretty hefty fines. So yeah, it seems like they are taking this pretty seriously.
That's correct.
Super. Thank you so much, Garth. Thank you for your time. I see Leanne has attached the notes for those of you that are wanting them. And again, Garth, just share your cell phone number for everybody, just in case they do have any questions, please.
Okay, I'm going to quickly type it in so it's on there. And like I said, if you don't get hold of me, drop me a WhatsApp. I love WhatsApps much better than emails for getting hold of me, and I'll get back to you as soon as I am available. There we go, 084-905-8003. And that's anytime. Please give me a call or WhatsApp me anytime. Even if it's at night, if I don't answer immediately, I'll get back to you. Thank you, everybody.
Great stuff. Thanks, Garth. Have a great day further.
You too. Bye, everyone. Bye. Thank you.
Bye.
Thanks. Bye-bye.